So it all stems from the Construction Contracts Amendment Act 2015, which amended the original act, which didn't include designers, engineers and quantity surveyors. Now, 1st of September 2016, it brought in that designers, engineers and quantity surveyors are now included in the Construction Contracts Act. By designers, it means architects, architectural designers, interior designers, and potentially landscapers, depending on the nature of that, whether it includes building or not, and that's a very much a grey area. The way it achieved it was that it redefined construction work to include the site or the potential site, so that a site where no work had yet been carried out, and so that architects and interior design, architects and designers, etc., could be then deemed to be working on that project and covered by the CCA, Construction Contracts Act, even if the building wasn't under construction. What designers and engineers and quantity surveyors do is defined as related services. A fee agreement will have to meet the requirements of the CCA. Fee claims should be formal payment claims under the CCA, and most people who have handled payments under construction contracts will be aware of payment claims. And of course the payment claim will now be accompanied by a Form 1. We'll talk more about Form 1 shortly. The client should respond with a formal payment schedule under the CCA, which again is familiar to those people who have done payments under the Act. If you have a dispute with the client, you can have it adjudicated, and parties don't necessarily have to agree to that. There are mechanisms for dealing with that. And if payments are not made, you can resort to suspend the work, and in some cases have a charging order, but there are exceptions to that. Now, in suspending the work, it is much more cut and dry than it used to be. You are pretty well protected as long as everything's in order, whereas previously suspending work could be, from a legal point of view, a bit on the dodgy side. You could be opening yourself up to legal claims. If the client has a dispute with you, they also can turn to adjudication, so it's pretty even. There's some concern about professional indemnity insurance providers. We have been waiting to see what professional indemnity insurance providers say about it, but they haven't said a lot other than that they're aware of it and prepared for it. But we don't know exactly how this is going to pan out. We haven't heard of any cases with respect to this, although the downside with adjudication is that it's confidential. So it may take a while before that filters out. Do you have to comply with the CCA? The answer is yes, you should. And the reason for that is there's no contracting out of the Construction Contracts Act. And that is section 12 if you want to read it. You just can't escape it. It will be there regardless of whether you take notice of it or not. If your fee agreement or fee claims do not meet the CCA, the default provisions of the CCA apply in section 15 if there is no fee agreement or bits of it are missing. You may be disadvantaged in any adjudication or court proceedings if this is not done. Your right to remedies under the CCA may also be compromised, so you might put yourself in a slightly difficult situation. Fee agreement under the CCA, parties are basically free to agree on a mechanism of determining how they do this. But they must include the number of payments under the contract, intervals between payments, and that can be defined in a number of different ways. Amount of each payment, and that again can be defined in a number of different ways. Date of each payment, that each payment comes due, and that again is variable. if a single payment is agreed. Now, the reason for that is a single payment generates different things to a multiple payments, in that the intervals are virtually non-existent, etc., etc. Again, if there's no agreement, then default provisions apply, and they are in the Act. Fee claims under CCA. This is described under Section 20, payment claims. And a payment claim must be in writing, identify the contract, i.e. project, identify work done and relevant periods to which the claim relates, state claimed amount and date for payment, indicate how the claimed amount was calculated. Calculations very important in this process. State that the claim is made under the Act. Be accompanied by an outline explanation to the payer of what they have to do with the consequences and the consequences of not doing it. And that's all about Form 1 that we mentioned before that must accompany the claim. Form 1 is included in the Amendment Regulations 2015. There's a copy of it there. MB have a convenient separate version of Form 1 available at their website. NZIA members will be able to get that from NZIA, and that's covered by Practice Note PN 3.211, which has proformas for payment claim proforma and the Form 1 basically. Payment schedule must be in writing. Identify the payment claim it relates to. State a scheduled amount. If the amount is less than the claim schedule, must indicate how amount was calculated. That's those calculations again. Their calculations as opposed to yours. Reasons for difference. Payers' reasons for withholding payment. You can't just hold the payment and not say why. Disputes, as we talked about before, can go to adjudication. They can extend beyond payments into other matters, but both the adjudicator and if it ends up in court will take compliance with the CCA into account. So legal precedence is showing that judges tend to prefer things to be in compliance with the CCA. Having said that, sometimes they will deem things to comply with the CCA. So be careful, you're best to stick with CCA requirements.